Open the meeting as an open session for Panel A of the Medical Board of California. My name is Dr. Ron Lewis, and I'll be chairing this meeting. First, we will do roll call to make sure we have a quorum, and if you could aid the court reporter in making sure you state your name clearly, it would help her greatly. And also, later on, when we are asking questions, please state your name before you ask the question so she has the right person attached to the question. Okay? So let's call the roll.
Dr. Hawkins?
Present.
Dr. Ormond?
Here.
Ms. Wright?
Here.
Dr. Yip?
Here.
Dr. Lewis?
Here, present.
We have a quorum.
Thank you very much. Okay, I'm going to now turn the meeting over to the administrative law judge, and who will introduce herself and also introduce the case.
All right, good morning, everybody. I'm Judge Schneider, and this is OAH 2017-120-955, and we're here for oral argument following the board's non-adoption of the administrative law judge's proposed decision. Can everybody hear me? How's this? All right, I want to talk for a few minutes about the procedures here and everybody's opportunities to participate. The arguments that counsel will make must be based on the existing record. No new evidence will be heard. The ALJ and any panel member can ask a party to support the party's oral argument on a matter with a specific citation to the record. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. The sequence of the arguments are as follows. The respondent will have 15 minutes for oral argument. The Deputy Attorney General will have 15 minutes for oral argument. The respondent will have rebuttal for 5 minutes, and the Deputy Attorney General will have rebuttal for 5 minutes. Now, Mr. Sloat, if you want to reserve any of your time to have your client address the panel directly, please let me know, and that time will be subtracted from your total 20 minutes of oral argument time. Do you wish to have Dr. Choi testify?
If you could subtract 3 minutes from my time, that would be good.
And how many minutes?
3?
So he will be addressing the panel. There will be no new evidence, but he may address the panel, and I will swear him in then at the appropriate time. So, and also, counsel, to both of you, would you like me to keep track of your time or raise my hand when there are 5 minutes left?
Would appreciate that.
Yes, Your Honor.
And where do you want the 3 minutes taken off, from the 15 or the 5?
Why don't we do it at from the 15?
The 15, so you'll have 12, and then 5, and then 3, and okay. All right, and please, can you state your appearances for the record with the board first?
Good morning. This is Lynn Dombrowski, Deputy Attorney General, on behalf of the complainant.
Adam Sloat, representing Dr. Andrew Choi.
All right, so Mr. Sloat, I'm going to tell you to begin, and then after 7 minutes, I'll raise my hand, and that will mean you'll have 5 minutes left. And then I'll give Ms. Dombrowski her opportunity to make an argument. So you may begin.
Thank you, Your Honor. So first, I'd like to thank you as members of the board for giving us the opportunity to come in for an oral argument face-to-face, because I think it's very helpful for you to see and hear from Dr. Choi, and I appreciate that. At the administrative hearing in this case, the Deputy Attorney General conceded that Dr. Choi, quote, has been a medical doctor with an outstanding record. Transcript, page 13. Dr. Choi is a fellowship-trained and board-certified facial plastic and reconstructive surgeon. He's also board certified in otolaryngology for head and neck surgery. Now, Dr. Choi has practiced continuously in the same community in Koreatown in Los Angeles for 33 years. He's had staff privileges at the Hollywood Presbyterian Medical Center in Los Angeles, and the record shows that Dr. Choi has the support of his medical colleagues, including the chair of the Credential Committee at Hollywood Presbyterian Medical Center. So the reason we are here before you is not because of Dr. Choi's practice of medicine. It's because Dr. Choi was convicted of driving under the influence of alcohol after driving home from a restaurant. The medical board filed an accusation to revoke or suspend Dr. Choi's medical license, and Dr. Choi contested it at an administrative hearing before an administrative law judge. Now, the judge issued a decision. That's a proposed decision. That's part of the record in this case. And the administrative law judge described the incident in this way, and I'm quoting from the decision. Respondent drank enough red wine and soju to cause his blood alcohol content to measure 0.18%, more than twice the legal limit. By his own testimony, respondent could have killed himself or another person by driving his car while so intoxicated. That's what happened. The judge also made the following finding. Quote, at the hearing, respondent expressed remorse, embarrassment, and shame for his misconduct. He testified that he will never again drive after drinking alcohol, and that he has reflected upon what could have happened on the night of the incident, stating, quote, I could have killed myself or somebody else, end quote. He has curtailed his consumption of alcohol, having consumed wine on 3 occasions since the incident. He is currently training for a 50-mile mountain bike race and is completely abstinent as part of his training regimen. In the morning, respondent wakes up early to go swimming, works out with weights twice per week, rides a stationary bike twice per week, and bikes for 5 to 7 hours on Sundays. This is what the judge found after seeing and hearing from the witnesses, including Dr. Choi. Dr. Choi also submitted to an evaluation by an addiction psychiatrist, Dr. Richard Sandor. And Dr. Sandor has 37 years of experience. He testified that Dr. Choi's DUI was, quote, an isolated, aberrant moment in his life. That's in the transcript at page 127. It does not show, according to Dr. Sandor, a substance use disorder. Page 126 of the transcript. Dr. Choi is 65 years old. He has been married for 38 years. He has practiced in the same community for 33 years. He is not an alcoholic. At the hearing, the medical board's attorney agreed, quote, he's a lovely man and does an excellent job doing what he does in his medical specialty. Page 13, the transcript. Even so, she asked Judge Goldsby, the administrative law judge who heard the case, to impose 3 years of probation with biological fluid testing and group meetings, she said. Page 223. Judge Goldsby considered the medical board's argument, but he decided that the appropriate discipline is a public reprimand. And this decision is acceptable to Dr. Choi. Judge Goldsby explained his reasoning. Quote, issuing a public reprimand is consistent with specific, he said, let me go through this at the beginning. Issuing a public reprimand is inconsistent with specific recommendations set forth in the board's disciplinary guidelines. However, a public reprimand is the most appropriate sanction in light of respondent's history related to his use of alcohol, the nature and extent of his misconduct giving rise to this disciplinary action, and the effective remedial steps he has taken to ensure similar events will not reoccur. A public reprimand ensures that respondent's misconduct will be a matter of public record, and it will serve as a continuing reminder of his responsibility to remain abstinent. Public protection does not require respondent be placed on probation or that any conditions be placed on the public reprimand. So back to why we are here today. Government Code Section 11517 authorizes you to reject a judge's decision. So the only way a doctor can win an administrative hearing is if the medical board lets him or her win. Someone once asked me, why would I exercise my client's right to a hearing if the board can reject the judge's decision? The answer is that I depend on your good faith to use your extraordinary power with great discretion and not to reject a judge's decision in an ordinary case. Otherwise, you risk creating a chilling effect on the constitutional right to due process, to create a situation where there's no incentive for anyone to exercise their right to an administrative hearing. Now, I just want to talk a little bit about probation, which the Deputy Attorney General is asking for. Biological fluid testing is like a medical procedure. It should only be ordered when it's indicated. Probation has unintended side effects, and it should only be ordered when it's indicated. Probation would have side effects in this situation. The record shows that Dr. Choi would be excluded by insurance company provider networks, and this would harm patients who need facial reconstructive surgery. That's at page 65 of the transcript. Another side effect of probation is the profound disruption to Dr. Choi's life and practice that would be caused by biological fluid testing with its daily check-in, frequent drives through LA traffic to a first lab test facility, to wait until you're called, and then essentially to pee in a cup before a monitor. Dr. Choi has more to contribute in the field of medicine. He testified that he is not ready to retire, but when he does, he will need an unrestricted license to volunteer with Operation Smile in Southeast Asia and the Philippines. I ask that you consider public protection through the wide lens that includes the benefit to the community of Dr. Choi's continued practice in his community. Thank you.
Yes, Your Honor, please.
We'll proceed.
Your Honor and members of the panel, in my allotted time here, I'm planning to just summarize the arguments that were presented in complainant's written argument as to why the proposed decision's discipline of a public reprimand is not appropriate in this case, and why a probation would be the appropriate discipline to render. The judge's proposed decision of that results in an order of public reprimand is inconsistent with the board's own disciplinary guidelines. Clearly, there's no dispute that the evidence established two causes for discipline against Dr. Choi. One, a violation of Business and Professions Code Section 2236, Subdivision A, which is conviction of an offense that's substantially related to the qualifications, functions, or duties of a physician and surgeon. And the other cause for discipline was established also, and that is the use of alcoholic beverages to the extent or in such a manner as to be dangerous or injurious to the licensee or to any other person or to the public. There is no dispute that that was proven at the hearing. The administrative law judge and the findings support those conclusions and those two causes of discipline. Although those conclusions were reached in the opinion, the problems occur in the proposed decision by the discussion of the mitigating factors and rehabilitation, particularly the legal conclusion numbers 19 through 22 that appear in the proposed decision. In those 4 paragraphs, the analysis and facts presented do not support the conclusion that a public reprimand is the most appropriate discipline. Admittedly, the respondent did produce at the hearing significant evidence of mitigation and rehabilitation. And through Dr. Sandor's evaluation, it was established that he does not have an alcohol use disorder as identified in the DSM-5. However, he was convicted, and the incident involved an accident after driving a vehicle in which he fell asleep and was found to have a blood alcohol content that was more than double the legal limit, 0.18% blood alcohol. And there was significant damage to his vehicle, such that it was damage to his front passenger side and was unable to be driven. It needed to be towed. I don't take issue with the statement in legal conclusion number 21 that respondent did rebut the presumption that he is a substance abusing licensee. There is no pattern that was shown of conduct in order to require that those guidelines be put into effect for the discipline. Those uniform standards for substance abusing licensees, I'm not arguing that those should be applied in this case, but instead the board should look to its own manual of model disciplinary guidelines in the proper or the appropriate discipline to render for cases involving a unprofessional conduct regarding under sections 2236 and 2239. As I pointed out in our written argument, the minimum discipline that is recommended for those violations is a probation of 5 years, with the maximum discipline being a revocation. As I'm sure this board is well aware, those conditions involve various options that include a requirement that he abstain from alcohol use, that he be tested to confirm that he is abstaining from alcohol use, a requirement that he take a course that is described as a professionalism program, which would be a course on ethics, and that if the board sees fit, they can require that he also be further evaluated if they find that Dr. Sandor's evaluation, there's some deficiencies in it. The proposed decision admits that in the proposed decision, the judge admits that it is inconsistent with the board's disciplinary guidelines. But the analysis that follows is not logical and does not support that the board should deviate from its own disciplinary guidelines to issue a public reprimand in this case. A public reprimand shall be limited to minor violations. And the unprofessional conduct in this case does not qualify as a minor violation. There have been no restrictions on Dr. Choi that require complete abstinence from alcohol. The criminal courts did not require him to be abstinent. He was only required to refrain from drinking and driving. He has never been randomly tested, and he himself testified that he has consumed alcoholic beverages since the arrest and conviction. And his testimony at the hearing was that he can recall at least 3 occasions when he has been drinking, and that he stopped because he was training for a mountain bike race. I would point out to the board in your review of the facts that Dr. Sandor, in his evaluation, which appears at Exhibit F, he makes an incorrect statement in that Dr. Sandor states that Dr. Choi is on, at page 3, the first paragraph, that Dr. Choi is on a 3-year probationary period during which he must abstain from all alcohol use. So in his evaluation of Dr. Choi, Dr. Sandor was under the mistaken belief that Dr. Choi was abstaining from alcohol. So the statement in legal conclusion number 20 by the ALJ that a public reprimand will serve as a continuing reminder of respondents' responsibility to remain abstinent simply has no factual basis and is not logical. Since he has had no requirement to remain abstinent, why would a public reprimand encourage him to his responsibility to remain abstinent? That is a inconsistency in the decision and an incorrect presumption of the facts as presented at the hearing. There is also no evidence that Dr. Choi has sought treatment for any alcohol issues other than attending the required meetings and first offender program that the criminal court probation required of him. So in legal conclusion number 19 in the proposed decision, it's incorrect when it states that during the almost 2 years since the accident, that he has taken responsibility for his actions and sought evaluation and treatment. He has simply fulfilled the requirements of his criminal court probation and has done nothing further with regard to any treatment for alcohol use. The mitigation evidence presented by the respondent does not change the fact that he has been found guilty of 2 causes for discipline for unprofessional conduct related to his arrest and conviction for driving while under the influence of alcohol at a blood alcohol level of 0.18%. Because of this, the board should follow its disciplinary guidelines that are set forth for those particular violations and issue an order of discipline that includes a stayed revocation with a probation with at least the special terms and conditions of abstaining from alcohol for a period of time and submitting to biological fluid testing, and a completion of a professionalism program. I note that the respondent is still subject to a criminal probation, but it requires nothing further of him. It is scheduled to expire in March of 2019. But this board, in order to protect the public and to assure rehabilitation of Dr. Choi, should comply with its own disciplinary guidelines and issue a probation.
Thank you, Your Honor. So, the Attorney General wants to do 2 things here. And I'm not speaking personally, Ms. Dombrowski, but what her office is asking for is that you treat Dr. Choi as if he's an addict, that he needs to be monitored. And the other thing that they're asking you to do is essentially to punish him again because of the crime that he committed and that he has been punished for. Now, public health initiatives for protection of the public, like vaccination or needle exchanges, are data-driven. Enforcement action by the medical board should also be data-driven. There is no data showing that a doctor who has a single DUI is likely to cause patient harm. There is no data supporting the effectiveness of biological fluid testing for a doctor who is not an alcoholic. It is like ordering a treatment which is not indicated. It would have been appropriate, perhaps, for the medical board to say, Dr. Choi, you had a DUI, it's a serious matter. We'd like you to be evaluated and see if you have an alcohol problem. And that is what Dr. Choi did voluntarily. And that was the appropriate way to protect the public. Now, shifting to the disciplinary guidelines. Page 1, first paragraph, quote, "These guidelines are not binding standards," end quote. Now, if we go to excessive use of alcohol or practice under the influence of alcohol on page 26 of the disciplinary guidelines, this is for alcoholics. 8 out of 9 conditions are for an addict. The only one that is not for an addict is the ethics course, which is 5, item 5. So item 5 suggests that addiction is an ethical problem because it requires an addict to take an ethics course. If we go to the other section, which is conviction of a crime, page 25 of the disciplinary guidelines, it says it is for crimes substantially related to the qualifications, functions, or duties of a physician and surgeon. Section 2239A of the Business and Professions Code provides that more than one misdemeanor or any felony involving the use of alcohol constitutes unprofessional conduct. In this case, we have one misdemeanor. Now, the Attorney General's office will argue that Dr. Choi used alcohol in a dangerous manner, and Section 2239A provides that use of alcohol in a dangerous manner is also unprofessional conduct. But it has to be substantially related. Using alcohol in a dangerous manner or any unprofessional conduct has to be substantially related. If there were 2 misdemeanors, it would be substantially related by law because there is a conclusive presumption of a substantial relationship. And this is clear from the end of Section 2239A, which states, quote, "The record of the conviction is conclusive evidence of such unprofessional conduct." So it's only talking about a conclusive presumption when there is a conviction. And that's when there's 2 misdemeanor convictions. So there's no conclusive presumption in this situation. Okay. Thank you.
Mr. Slotin, his representation of there being a requirement that there be 2 misdemeanor convictions before the board can exercise its discipline is incorrect. In fact, there was a recent appellate court decision involving the physical therapy board in which the appellate court, this is Walker, I cited in my brief, it's Walker versus Physical Therapy Board of California, 16 Cal. 5th, 1219, in which the court considered that argument with regards to 2239 and determined that there was no requirement for 2 convictions and that a discipline was permissible under that section for a single DUI involving a health professional, a physical therapist in that case. So there is no requirement that there be that nexus found before this board is able to exercise its disciplinary authority against Dr. Choi. According to Section 2229 of the Business and Professions Code, this board the protection of the public shall be the highest priority for this board in exercising its disciplinary authority. But that section also states in subdivision B that whenever possible, the board should also take action that is calculated to aid in the rehabilitation of the licensee as well. And in this case, in order to be assured that Dr. Choi is able to abstain from alcohol and that this was an isolated incident. The board is fully authorized and within its guidelines to require a probation and certain terms such as abstaining from alcohol and being tested to confirm that abstinence. It will not, the proposed discipline that I am arguing for would not only protect the public, but would aid respondent as well.
Dr. Choi, would you like to stand and I can swear you in?
Then you're going to sit down again. We just stand up for just to be sworn in.
Raise your right hand. Do you solemnly swear or affirm under penalty of perjury that your testimony is the truth, the whole truth, and nothing but the truth? Be seated. And you have 3 minutes to make any statements you wish to the panel.
Thank you for giving me a chance to express my situation, and I felt through this the hearing and previous hearing, I felt very embarrassed and shameful. The past 2 years since the DUI incident, I was not able to tell any of my colleagues and that this incident happened, and even to my family member, I felt really shameful. And I swear that this incident is not going to happen again. I still want to continue my practice. I still want to help my patients, as I has been for past 30-some years. So please take into consideration about my plan, and after a few years of my practice, then I'll retire, and then I'm gonna do the volunteer work, which is my favorite work after my career. And I've been to Philippines to help the cleft palate patients through the. And then I still want to continue to do my volunteer works. Thank you very much.
I would like to now turn to the panel members to see if there are any questions.
I have nothing at this point.
Dr. Choi has mentioned that you have 3 incidents that you still drink after the incident. Do you plan to not drink anymore, or you plan to continue to drink? And that 3 occasions you drank, did you have someone to drive you afterwards?
As far as I understand that, actually, to answer to your question, because of this incident, my attitude toward alcohol has totally changed. There is no the enjoyment after drinking since this happening. As far as I know, that I was not allowed to drink and driving even small trace amount of alcohol in my system for 3 years. That was my understanding for 3-year probation, which is going to be 2019. I cut down a lot of I didn't actually only drink for past 3 years. I drink 3 times. That was only socially. I cannot avoid to drink, but maybe 1 glass of wine. That was the case. But because of my current preparation for my race, that I completely discontinued drinking.
That was my question. Same question.
Dr. Choi, I was trying to look in the record to see what you have done as far as rehabilitation from your incident. you had one DUI, and I'm not quite sure what you have done since that time, except now had 3 drinks. So if you could tell me what programs or your attorney can point me to
Can I?
what has been done
Sure.
since that time?
So, the court immediately, there were requirements from the court. And one of those is an alcohol education program that everybody who has a DUI goes through. And that is one of the elements that was shown at the administrative hearing, is the completion of that course, I believe, right?
Yes.
Yeah. And how long was that course?
The 3 months.
So this is the 3-month alcohol program that is with a first-time driving under the influence case. And so Dr. Choi completed that, and as part of the probation from this court, they also require people to go to AA meetings as a visitor to observe and see how other people have gotten into trouble with alcohol and how it's affected their lives. And Dr. Choi did attend those AA meetings and did have that experience, and I know that because we've discussed that. He has not had a alcohol recovery program, rehabilitation program for somebody who is an addict or has a substance use disorder because it wasn't indicated. He doesn't have an alcohol use disorder.
So just to summarize, Dr. Choi only followed the court recommendation order to take the education course, but either from the court or his own doing had not taken an AA program or enrolled in an AA-like program. Yes or no?
No. If the answer is, did he go into an alcohol program for recovery of an alcohol problem, the answer is no.
Yeah, it's just, if it's for my information, I couldn't
Yeah.
find it in there, so.
Yeah.
That's
But the AA was court required as an but only really for educational purposes rather than for treatment purposes.
right, as far as the court recommends.
Correct.
This is the medical board, give
Fair enough.
the
Yeah.
recommendations, so,
Yeah.
thank you very much.
Ms. Wright.
I have a question for the DAG, and then I have a question for you, sir. You said that the ALJ's reasoning was not logical. Obviously, the ALJ has a different advantage than we do because they get to hear testimony and witnesses, and we're in a limited scope now. And you said that there were presumptions in some instances, which happens in the law, right? So we don't necessarily have an indication that Dr. Choi is a substance abuse or an addict. So, and you talk a lot about legal conclusion 19. So the ALJ felt public reprimand was important. So can you tell me, with the understanding that our guidelines are modeled, and sort of succinctly why the ALJ's reasoning was illogical in a way that kind of says this is why public reprimand is not appropriate for this doctor who's had sort of a singular instance of a DUI?
First of all, public reprimands are disciplined for minor violations, and a violation of both 2236 and 2239 for a DUI that involves blood alcohol of 0.18, I argue is not a minor violation.
Can I stop you there? Say it to me like I'm ignorant and don't know what any of this means. Tell me, if I'm a layperson, why? Just like.
Well, because a physician with his training and experience and knowledge about the effects of alcohol and driving exercises such poor judgment that he endangers his life and the life of others by getting in a car after having been drinking, and with that level of over double the legal limit, that is a dangerous situation. That is not a minor violation. And so the board has to consider that, and they have guidelines. He is not the uniform standards for substance abusing licensees requires very arduous probation terms. But there's also terms that are provided by their own model disciplinary guidelines that involve similar but not as extensive restrictions on a practice. And that is what is appropriate in this case to be looking at. He doesn't, finding that he is a substance abuser is not a requirement before you issue discipline under the guidelines. So that is why the probation is appropriate. And to issue a reprimand, it would indicate that this board feels that's a minor violation.
And sir, to you, understanding that our, paramount thing that we're supposed to do is public protection, and also what you've heard the DAG say, what is your response to that? You succinctly, please, talk to me like a layperson. I am a public member, but I'm also a lawyer, but say it in plain language, please. Why should we go with the rationale of the ALJ and stick to the public reprimand versus giving your client probation for this incident?
Because the ALJ, who saw the evidence, saw the witnesses testify, he concluded that there wasn't a risk to the public of Dr. Choi drinking and doing this again or causing harm to patients, and that there wasn't a risk that required monitoring that probation provides. I don't know if that...
Oh, I want to hear, advocate for your client. Tell me why we shouldn't give him probation.
Because he is not going to do this again. He is a good doctor. He is one of the good doctors who needs to continue practicing in his community. And he needs to be free to take care of his patients, travel, help people in other countries, and to restrict his practice and his ability to do that to meet guidelines that are designed for a wide array of doctors who may have an alcohol problem, who repeatedly violate the law, wouldn't be appropriate for him. It would cause more harm to the public than it would help. Because if you put a doctor on probation, you take him off insurance. So now he doesn't get Blue Shield, he doesn't get Blue Cross, Cigna, Aetna. So you just eliminated all the patients who need reconstructive surgery and who are insurance-based patients. Now his practice gets essentially limited to elective cosmetic-type procedures, and he can't travel easily. He has to be going to First Lab to test 2 days a week, get there by the end of the day. It could take an hour for him, and it's very restrictive. In other words, probation is extremely restrictive.
That sounds like an inconvenience to the doctor. How is it an inconvenience to the public? You see what I'm getting at with my line of questioning?
Yeah. I think what you're doing is you're losing his services for the public. That's what you're doing. You're saying, okay, so now all people in this area of Los Angeles who would go to Dr. Choi for important facial reconstructive surgery, who are insurance patients, they're not going to be having that option. That's the first thing. And at some point it just becomes, travel is very difficult for somebody who's on probation because you have to be able to test. So that eliminates his ability to travel and take care of patients in other countries like the Philippines. So it's a big step to put a doctor on probation, and what I'm saying is that it isn't warranted in this case, and it's not something so minor that you could do it just as an extra precaution.
Dr. Andy Hawkins. I think I'll ask my question anyway, and I'll ask about Dr. Choi. Dr. Choi, why haven't you stopped drinking entirely?
Can I ask you a question again?
I said, why haven't you stopped drinking entirely?
I stopped the drinking entirely right now.
Entirely forever, to the best of your knowledge.
Yeah, that's what my plan is.
I didn't hear you say that.
Yeah, I'm not actually enjoy drinking anymore, and I just stopped drinking.
I thought, and you can correct us, I thought you stopped drinking because you were training, but you only agreed you would stop drinking if you were going to drive.
Oh no, my point is that what I misunderstood, because when I got the 3-year probation, that was the case. But personally, I don't actually find drinking the alcohol at this time since the incident. The 3 occasions that I drank is just because of social pressure. I just kind of drink maybe a glass of wine, but that was not for drinking for that reason.
When was the last time you drank?
I don't recall, but that was a long time ago.
Oh, thank you.
Any other questions? All right, this matter will stand submitted.
Going to go into closed session now, so many need to exit the room.